everyone. Welcome to Friday afternoon stream, Friday evening. We are going to be talking tonight about the loser family known as the Owens. First, we're going to start with we're going to talk about their bankruptcy disasters, because there's nothing better than being famously known for lying and perjury and being brought up on those criminal charges, then going ahead and lying in your bankruptcy hearings as conflicted by the original evidence you provided in the case where you were found to have lied. And then we're going to move on to her parents, because her mom and her are exactly the same. It is such a disaster. But with that said, let's get it going. Please remember to hit the like button if you enjoy what you see here. And for those that are new, there's plenty of playlists in the description of this video for all the different subjects we cover here, which is basically just a bunch of morons. All right, let's go ahead and get it started. Yes, I know it's later than you'd want normally, but I said I would stream Friday, and I got engrossed. I got caught up in a project and was doing work because I have a full-time job. But I figured we could at least get this out here. So we're going to start with Laura Owens' bankruptcy. That was back in February 2020, or February 20th, 2026. She was trying to declare bankruptcy because of the huge bill she has from the case involving Clayton Echard, the ex-bachelor, when she tried lying about being pregnant. This woman makes up the dumbest lies and sticks to them no matter what. I'll share my feelings, my opinions sometime on whether I think that she will take a plea deal. I don't think she ever will, actually, but I won't say why. But she just got a recent 90-day extension. The trial's pushed out. So in the meantime, let's watch this here. And so,
yes,
for those who don't know, what happened in that case with Clayton Echard is she was trying to buy real estate through Clayton Echard. Clayton Echard had just become a real estate agent as an investment property, some bull crap. And then she went on record saying, oh, I have all this money and everything. And now she's trying to claim bankruptcy. And she's giving totally different answers. And I wanted to include the first portion where she's made to take the oath, because I don't think these people actually understand when they're asking, hey, you understand you need to tell the truth, right? Yes. All right. Were your forms filled out to the best, or to truthfully and accurately? Yes. They don't understand that that's not where it stops. It doesn't stop with just saying, yeah, that's true. All right, let's lock it in as evidence now. No, they're going to question you. Anyway, here we go.
Would you state your full name for the record, please?
Laura Michelle Owens.
Ms. Owens, do you understand the importance of the oath you just took?
Yes.
Is your address correct as it's listed in your petition?
Yes.
Is that where you
And she lives with her parents.
currently reside?
Yes.
Did you receive the bankruptcy information sheet I sent out?
Yes.
Had you lived in Arizona at least 2 years before you filed this case?
Yes.
In the past 8 years, have you filed another bankruptcy case anywhere?
No.
Did you review all of your bankruptcy forms and paperwork before you filed it?
Yes.
No, Rob Neater Pro, I understand that they don't understand the oath to tell the truth means, but I'm saying when she's saying yes to all this stuff, did you review this before you filed it? Yes. Did you sign everything yourself? Yes. If they have evidence from it, this goes to your credibility. Don't say yes if you didn't do it, which she will immediately turn around later.
When it came time to sign any of those documents, did you physically sign them yourself?
Yes.
Do you
I mean, even that. She later says no. Well, my lawyer signed it electronically. Why? Why get caught in these stupid little lies? Yeah, it is my favorite quote from her. I'm going to jail because I slept with the Bachelor. No, not because I slept with the Bachelor. I'm going to jail because I got pregnant by the Bachelor.
understand that you signed those documents under oath?
Yes.
Are all of your assets identified in your schedules?
Yes.
Are all of your creditors listed there?
Yes.
Are you paying or do you owe any child or spousal support obligations?
She wishes. Oh!
I do not.
Have you filed tax returns for all years up through 2024?
Yes.
I got a 2024 tax return copy from you. What is the status of 2023s? That would have been another one that I asked for.
2023 should have been sent as well with the 24. I know my civil attorney, David Jinkers, had been helping me, and I thought he sent that one over.
Okay. Can you guys confer after we deal with the meeting today and follow up and get that to me?
I guess the other thing to mention is their stupid lawyer, Gingras, David Gingras, who's almost as bad as the truth. Or he's worse than her because he knows she's lying. Well, she knows she's lying too, right? But she's got some kind of mental disorder, her and her mom. It's like pathological to them. But David's like a dick while he's lying and pretending to gaslight us all like that we don't know that she's lying.
Sure.
And he's blocked me on Twitter or X and his little blog. And I think he's being disbarred, isn't he? I don't know. I read something on his blog where he's like, yeah, it doesn't matter. Okay, can't practice law in Arizona. Who cares?
I get it.
But he's here with this, but it's a limited appearance.
The 2024 tax return copy that I did see, was that a true copy of what you filed for that tax year?
Yes.
All right. In the past year, have you made any payments to any family members or friends?
No.
In the past 2 years, have you sold, given away, or otherwise transferred anything?
Yes.
Okay, and you answered yes to that on my trustee questionnaire. I don't remember seeing anything about that in your statement of financial affairs, but what are you talking about when you say yes to that answer, to that question?
Yeah, I started an LLC called LizMax Investments LLC.
All right, this right here, right off the bat, doesn't make sense. It's named Liz Max. Her mom, so her parents, which are the other bankruptcies, sorry, I assume everyone knows this stuff, but doesn't. Her parents are Ron Owen and Elizabeth Naylor. Now, Elizabeth Naylor also goes by the alias Jan Black because if she was a reporter or whatever. So her mom's real name is Elizabeth, and so it's Liz Max, and it sounded like it was some kind of stupid Airbnb. But listen to this story. I started an LLC, and okay.
And it was supposed to be for investment properties, and my mom ended up being the one who provided the down payment for a property, and she. Okay,
your mom, you founded the LLC. Your mom provided the money, and then
she ran it herself. It wasn't something I ended up having anything to do with. So.
And then she ended up running it by herself. So that sounds like you didn't do anything with that, Laura.
I gave her the LLC. I just took my name off of it.
Okay, and we've already done some preliminary work in here, and if I understand it, and correct me if I'm wrong, the real estate that was the investment in that LLC the LLC no longer has it. The bank took it back.
Yeah, it was forfeited.
Okay, is that the only transfer that you that you made to any insiders, family members, friends?
Yes.
What about Frosted Flakes? The horse. Such a funny name.
Or rather, that was the question. Was that? I'll ask it again. In the past 2 years, have you sold, given away, or otherwise transferred anything? So that's it. Whether it's an insider or not, that's the only thing you've transferred in the past 2 years?
Yeah.
Rob the Eater Pro, if you look at the screen, it clearly says totally not crazy. All right.
Yes.
In the past 3 years, have you been a plaintiff in any personal injury litigation or some other kind of claim settlement?
Not personal injury. Nothing I would be entitled to money in.
Do you have any claims like that available to you that you've not begun to pursue yet for whatever reason?
No.
Do you currently have any ownership interest in real estate, whether it's through another entity or personally yourself anywhere?
No.
Are you the beneficiary in any trust or other kind of an estate?
No.
Have you gotten a divorce in the past 2 years?
No.
Okay, I don't have any.
She should start laughing. Sir, I can't even sue people into dating me. How am I going to get married?
Any other questions? And I'm going to open this up, but I don't think, based on last the last meeting that most of these people want to ask any questions, but I see Ms. Jaimo from the UST is here, and I'll give her the right of first refusal. Did you want to ask any questions, Ms. Jaimo?
And here comes our hero, Jennifer Jaimo, who is the literal thorn in the side of the Owens family. Well, I mean, it's not hard to do what she did. I'm not saying she didn't do anything good. I'm saying you can put all the numbers in the spreadsheet, and it's very easy to figure this out. Plus, when people give you two different sets of numbers, usually indicates some kind of deception or fraud. And when you can't even get the term gross revenue right, and then you keep saying you understand it, and then you keep redefining it as net income, God, it's so frustrating. But if we didn't have Jennifer Giamo, this would be much more painful to listen to.
Yes, Mr. Haley, do you mind if I have, maybe it's 10 minutes? Is that too long?
That's fine. This is the last one of the day.
Okay, so Ms. Owens, I'm an attorney with the U.S. Department of Justice, the U.S. Trustee's Office, and we oversee these bankruptcy cases sort of as a watchdog. And I had gone through your bankruptcy documents, and I just want to ask you some questions about some of them. But before I do, I just want to make sure. So is Mr. Gringas that's on here, is that your attorney for the bankruptcy case?
It's Gingras.
He has been helping with the adversary proceeding, but he's not my bankruptcy attorney. No, I'm pro se, but he helped me because I confused some of the filings.
I can clarify that if you need me to answer.
Yeah, yes, please.
There's an adversary proceeding that's attached to this. I represent Ms. Owens in the adversary proceeding, but only that, not in this main bankruptcy case. I'm obviously involved in the adversary part of it, and I've been communicating with Mr. Haley and his counsel as well. But I've not appeared for Laura in the bankruptcy, and I don't intend to if I don't have to. But I'm just on standby for now.
Okay, so Ms. Owens, I'm probably going to end up after this noticing your deposition and formally asking you for documents. So that's something I should ask of you personally because you don't have an attorney, correct?
You should be getting nervous at this point, Laura, which you're not because you're stupid. And you're stupid for having David Gingras as your lawyer. He not only lost your case for you, he teed you up to perjure yourself. Now you're facing felony charges. Why are you still hanging with this guy? He's the worst lawyer ever.
Yes.
Okay. So I want to start with, I see that recently you amended the schedules of your assets to include a couple of Bank of America's accounts and an E-Trade account. Is that correct?
Correct. I had listed them in the wrong spot on my filing.
Okay, so what had prompted you to file the amendment? Were you just going over them and realized, oh, this was not in the correct place?
I believe that Mr. Tate had questions. He was assisting Mr. Haley, and he had questions. And so then David had helped me with making sure everything was in the right spot. So I guess, in re-amending the schedule.
I hate her affect of how, it's just everything. I don't know. And her mom does it too. Like, it's so confusing. It's so confusing. I don't know. Oops. I'm just a simple person. I screwed up my thing here.
Ms. Jaimo, I think you might mean Terry Dake.
Yes.
Oh, I'm so sorry.
Okay,
I'm so sorry. Yes.
You said Tate. I just wanted to make it clear. Okay.
Yes. Sorry about that.
Okay. So.
You've never heard of a bankruptcy interview like this? You mean like just in general? Or like one that goes down like this? Is that what you mean, the accidental cleavages?
Having seen that you amended the statements to identify those accounts, do you have copies or can you easily get copies, like electronic copies of the bank account statements for the Bank of America account and the E-Trade account for 2025 and 2024?
Yeah. Mm-hmm.
Okay, are those accounts still open?
The E-Trade one is that I think is the same as more.
The other frustrating, why don't these people ever bring their paperwork? Oh, is this one? I mean, I know it's a tactic where they don't want to get nailed down to it. So if they don't have the paper in front of them, they go, yeah, I'll take your word for it. Oh, I misunderstood that.
Morgan Stanley, I think it is. It is that I think Morgan Stanley owns E-Trade. I think that's what it should be listed under. Do you see that? It's like
I'm just looking at your schedules, and it indicates E-Trade account.
Okay.
You wouldn't have a bankruptcy lawyer because they're expensive. And I think there's some rule about paying for a bankruptcy lawyer when you are claiming you have no money. I don't know.
Then that's what I'm thinking of for the Morgan Stanley. I don't have like another. I know that's confusing what I just said, but I definitely do not have another bank account that's not listed. The E-Trade account. What was your question on that? I'm sorry.
If you can get copies for 2024 and 2025 of the statements.
Yes, we will listen to the 716 or the 618 hearing of her parents after this. It's going to be a two-parter because there's way too much audio for all of it. So, yeah.
Yes.
Okay, so that's not going to be a problem. So I'll be asking that of you in formal document request.
Yes, that's no problem. I can get that. Yeah.
Okay, very good. And I see that you added that you have a potential tax refund of about $891 for 2025. Is that correct?
Yes, I think that was for 25.
And where did you come up with that figure? That precise figure?
I did it on Credit Karma. I did like my taxes on Credit Karma, and they came up with that figure, but then I never got a refund, so I was just presuming it was.
I can shed some light on that. That's the Ms. Owens, that's the amount that's listed on the 2024 federal return that I got from you. So it's I assume it's your testimony that you never received that.
No, I did not.
Did you file that timely? You filed that 2024 return when
send it in
on or before the deadline, or maybe the extension deadline, which would have been near the end of 2025.
Yes.
Okay.
Doubtful.
So speaking about the tax returns, Ms. Owens, will you permit Mr. Haley to share copies of the tax returns that you provided him and are going to provide to him with me?
Yes, absolutely.
Okay, so Mr. Haley, you have no problem sending those to me, correct?
I do not.
All right, thank you. All right, did you have a CPA or accountant or any financial, bookkeeper, somebody assisting you with your tax returns or not?
No, I just used Credit Karma.
Okay.
Who uses Credit Karma to do their taxes? Ugh.
And I see that in your schedules you listed debt to Cherry Tech, and that's a lender for Innova Med Spa, correct?
Cherry Tech is a lender that I used for Botox and for like a skin firming treatment that I got. I don't know if they're with Innova Tech, but that's not what I used it for. It was Cool Sculpting was the one I used it for.
Well, I would say it was money not well spent based on your face. But she's using for Cool Sculpting. She's already thin as a rail. What is she doing? You don't have money to do this, ma'am.
I would provide the place, the name of the place that did that.
I don't absolve Ron of his participation in this, but I do feel sorry for Ron being so sick and being stuck with these two nightmare women, his daughter and his lunatic wife.
As well.
Okay, so you never obtained any loans from Cherry Tech based on services or products that you purchased from Innova Med Spa?
Not that I'm aware of. I mean, I've gone to a lot of places for Botox and procedures, but that's
no
not
kidding,
where
huh?
I think I did anything for Cherry.
Okay, so do you have documents that show, invoices, copies of that sort of thing, that will show the debt that you owe to Cherry Tech that you listed here in the schedules?
Yeah, I should.
All right, so those are also documents that I'm going to ask for in my formal document request. So.
I mean, honestly, I don't know why they think. Do they not understand what bankruptcy is? Like, they want to see your records. She knows how house buying apparently works. She's got through that. It's the same thing. You have to prove your income. You have to show all your bank records, all this stuff. They're just shady as shit. Oh, you want proof of it? I thought you just could write it in there.
Okay. And just be aware, please don't destroy any documents right now while you're in bankruptcy. It's crucial that you keep all your documents. We're going to be asking for some documents, and even if we don't ask for them, we shouldn't be destroying anything right now.
Okay, yeah, I'm not.
Okay. All right.
Okay.
So on Schedule I, it indicates that you had 0 income. So no income from wages or operating a business, correct?
Correct.
Moron.
And so
This is the dumbest
what
lie.
time period were you stating that you had no income for?
I mean, I haven't ever in my life had like a 1099 or W-2 job, but I've, really been supported by my family.
So never in your life have you received a 1099 or a W-2 from any business, including your own businesses?
Correct, never.
Have you ever received any kind of tax form like a Schedule K-1 that indicates that you have a certain share of earnings from a partnership or an interest in an entity?
No, I know that the LLC, my family's LLC business taxes are filed on a Schedule C. And that's all I know.
But you are the owner of at least 4 entities that you identified in the Statement of Financial Affairs. You are an owner of at least 4 entities.
I think that I would consider it to be like 4 I was associated with. Maybe David could offer some clarification because he
No, he's not your lawyer in this case, ma'am.
helped me answer that question.
Yeah, throw your lawyer. He helped me answer that question. How do you not know if you own a business? Plus, you put owner on LinkedIn, you dumb.
David?
Well, let me just pipe in here. Either Mr. Gringus represents you or he does not. So I'm not comfortable with having Mr. Gringus step in as your counsel,
Right.
She's declaring the roughly $200,000 she owes to Clayton Echard's lawyer for fees for her lying about pregnancy.
So, if he's not your counsel here, unfortunately, no, he cannot be, advising you on how to answer that. I guess, do you have a copy of your Statement of Financial Affairs in front of you?
I do not, but
What is wrong with you? What is wrong with you and your mother?
I have always thought I was the manager of LLCs, not an owner, and I have not ever filed them on my taxes or anything.
Okay, just because I want you to be aware that if you look at your own statement that you filed under oath, you check off the box that you are an owner of at least 5% of the voting or equity securities of these 4 entities: Quartet, Lizmax, Keybacker, and Stylet. So is that incorrect information that you put on there?
Uh-oh. I hate it when she cries.
I thought it was if I had been known to have any identity with those, and I knew they were ones that my name has been associated with over the years, and I was trying to cover my bases.
Always trying to cover your bases.
In terms of listing which ones I've been a part of.
Okay, and also I looked at your LinkedIn account, and it indicates on the LinkedIn account that you're an owner, an executive with those entities. Is that not?
I mean, they're really not operable. I mean, I'm trying to market myself as an entrepreneur, but it's not like I've got these businesses that are, operable.
What the f*** are you talking about, lady? You put on LinkedIn you're the owner. You put on your Schedule I that you have a controlling interest of at least 5% in these 4 businesses. And now you're trying to say, I was associate.
Okay, I'm not asking yet about whether they're operating. I'm asking about whether or not you are an owner, and you hold yourself out to be an owner of these entities on your LinkedIn account and on your sworn schedules in this case. So, and now you're saying you're not an owner. You were just, well, I don't know what you were. So were you an owner of the 4 entities?
I mean, I'm more like, they're my family's entities, and I'm more like the face of my family's entities with.
Ugh. Who wants that face? Oh my God.
businesses, I guess.
Okay, well, we can.
That's the best way I would say that. I know I'm not answering it well. I'm not trying to not be truthful. I genuinely.
Start crying, Laura. That'll definitely get you sympathy from this very smart, very precise woman that believes you are lying.
Don't know how to explain it.
Okay, well then.
You don't know how to explain it in a way that doesn't elicit an answer that isn't good for you. You don't know how to get her to stop asking questions, is what you mean. I don't know.
You'll have to make sure, I'm going to recommend to you that you go back over your schedules, that you sign up for penalty of perjury and make sure everything's accurate, because you have in your sworn schedule stated that you are an owner of those entities.
Okay, I will go back and reevaluate that. I'm sorry.
Okay. All right, so on Schedule I, which is where you were supposed to list your income on the bankruptcy schedules, you added a line item on 8H for family support for food and living expenses, and you put 0. So was that a mistake?
Moron. Don't list anything if you're going to put 0. At least get that right.
Do you receive any kind of family support to pay your expenses, your monthly expenses?
They just pay them out of their money. I don't, out of my parents' pension and Social Security. They don't give me money to pay that. They pay it directly.
So who gives a shit? Plus, your mother's going to ballpark it later. Ballpark it at $19,608, I believe. That's just a ballpark. Very specific number.
What are they paying directly when you said they pay it?
Well, I live on their property, so, I mean, you could technically say they're paying, housing and for my food.
Okay, what about your car payments?
We share a car. They pay for my car.
Okay, so they directly, because, you are the sole owner of the car.
I'm the sole owner, but they're paying for it right now because I can't afford to make the payment.
Look, Jennifer Giamo. It's very simple. Laura wants to put down that she has no income because her parents pay for everything. And her parents also want to put on their schedule that they have no money because they give it all to their daughter. Okay? It's very simple to understand.
Okay. So, that's something that you do need to specify how much it is, even if you have to come up with an estimate on Schedule I of your schedules. You have to indicate how much money they're fronting for you for your expenses.
Okay.
You just leave it 0.
Okay.
So you'll need to figure that out and amend Schedule I, okay?
Okay.
If I may, please, why did she need a fake pregnancies? Well, because Clayton Echard didn't even sleep with her. The other men used protection. And, she wasn't able to, poke holes in the condoms early enough. And then she'd fake the pregnancy. Because she's horribly clingy and, she creeps people out, obviously, in the first instance. She is 40. She's, in this call, she is 35. She will be turning 36, or she turned 36 in May of this year. Yeah, she's a lazy piece of shit. Hell. How about get a job, Laura? Because businesses that you say that you owner, not owner, more of the face of, an associate, they all lose money apparently. Why don't you do something that makes money?
So, and I'm assuming your parents also pay your car insurance?
Yes.
Okay, so you don't pay any bills for yourself?
No.
And you say that you've never... Are you saying that you've never earned any income on your own, ever?
Correct.
Oh my God. What a loser.
If you get the opportunity, you should kill yourself.
Okay, how old are you?
I'm 35.
Exactly.
So 35 years you have not...
Jennifer has to confirm. Wait, how old are you? 35 years you've never had a job?
Never had made any income on your own to pay your own bills?
I mean, like I said, I'm at the base of my parents' businesses, so they've, paid my living expenses in exchange for me helping them.
Okay, so that's kind of a compensation for your services then.
Yep. How do you not get this?
I mean,
And this isn't even the bad part.
yeah, I mean, I don't take advantage of it, but,
No, she didn't sell real estate. She ran a stupid podcast with her mom called Nobody Told Me. That's why it's so funny to make the joke, like on the thumbnail said, nobody told me about that what gross revenue is. Nobody ever told me that lying in court is perjury. Nobody ever told me perjury is a felony. Nobody ever told me you can't get pregnant without having sex.
Providing them with services and they're compensating you by paying your bills, is what you just said, right?
yeah, exactly.
Yet nobody told me that people don't instantly like just wipe their minds every time they talk to me, and I am very bad at lying and I get caught at it because I'm not very smart. Nobody ever told me that. She but as far as the real estate, she was she what's the word? She positioned herself with Clayton Echard as somebody who was buying real estate for investment. But as you can hear with the Lizmax Airbnb, the investment property they did buy, they surrendered it because it made no money and they were underwater, right? So.
Well, then you better figure out how you're going to want to disclose that in these schedules, because that is a form of compensation. I would recommend that you really read through what the schedules and the statements require you to disclose.
Bye, Trishy.
And we'll go more into this because I'll probably have to take your deposition, but I wanted to make sure to give you an opportunity to amend anything that you were contending was just an innocent mistake.
This is getting really serious. All I do is get pregnant by the Bachelor.
Make sure.
She's talking to the attorney for the trustee, the government, right? You get examined because the government, I don't know. I'm not going to explain it right. But basically, there's protections when you declare bankruptcy, right? So in order to find out if you really are eligible for bankruptcy, not somebody that's just going, oh, I declare bankruptcy, like Steve Carell in The Office, they're going to do some like investigation, especially like when their parents get into it. If you're filing bankruptcy as a stay on foreclosure, then you say, oh, no, never mind, I can just cancel it. They're not going to just let you go because you've taken advantage of the bankruptcy protections and then you don't follow through with it. It's to prevent gaming of the system, which is exactly what the Owens are trying to do.
To give you an opportunity to amend anything that you were contending was just an innocent mistake.
You're contending just an innocent mistake. That's not good.
Okay, so the biggest issue I had was that, regarding this claim of yours that you don't make any income. So you are aware that on the Statement of Financial Affairs, you did not disclose receiving any income of any kind for 2023, 2024, and 2025 through the date of the bankruptcy filing. You're aware you did that, right?
Yes, I didn't understand that how I was supposed to say if my expenses were getting
Oh my God.
paid for.
No, we're not
Nobody can be this stupid.
talking about expenses. Right now, on the Statement on the Statement of Financial Affairs, on items number 4 and 5, and you could take notes if you want so you can follow up and look,
Okay.
into this.
I don't have a pen, but I have my phone hand. Sorry.
You don't have a pen?
So it's not the schedule, it's the Statement of Financial Affairs. Mm-hmm. And you've recently amended it.
The dinging in the background, by the way, of people logging on reminds me of the you can be making so much more money, Lauren call with just the bloop bloop donations of guys sending $6 to see Jamie Flash. Oh, it's so glad it's not in Lauren live tonight. Oh, Tabby. I it's a great story.
So
That's what actually I was working on. I'm trying to get the entire story down for the art of the Jamie Amy saga.
It's items number 4 and 5 required you to disclose all income you received, even if it was non-taxable income.
Okay.
There's
Okay.
2023, 2024, and 2025 up through the date you filed the bankruptcy petition, okay?
Okay.
So, I guess let me ask you, does your 2024 tax return indicate that you received any type of taxable income at all?
No.
Uh-oh. It's not good.
I know I was under the limit, but I just thought I had to file it anyway.
So what do you mean you were under the limit? Under the limit? Are you
For like,
No, I feel sorry for you, Tabby. You will enjoy it once you consume enough.
I know there's like some, if you make below a certain amount, you don't have to file, but I thought I did
Lauren interview, the one he did. Yeah. Tell me what you mean specifically, Insecure. Sorry. Which one?
need to file anyway.
Okay, but so it wasn't 0 though. So you might have been below the threshold for there to be a tax, but you did make some money. Is that what you're saying?
I mean, not to me. I mean, if you're going based on what my parents paid for, then yes, but I didn't make $1 last year.
Yes, you did, you dumb. I'm sorry, accidental cleavages. I'll try and get one for tomorrow, okay? But for example, here's what she's trying to do. YouTube sent me some money last year, right? Now, I'm not going to have to pay tax on it because my expenses vastly outweighed the income, right? So I will show, though, that I had YouTube income on a 1099, and then I list my expenses, wiping out that income. But expenses for the stream, not just daily expenses, right? Like the trip down to Florida, the mixer I got, the new camera, right? So I'm not a blurred blob anymore. But that would still be listed as gross income and then expenses on Schedule C, probably, or whatever. I don't know. I know, I mean, everyone thinks that accountants know all about taxes. I don't do taxes, but this concept is not hard to think about, and she can't be this stupid. So she's just trying to play stupid, and then she will retreat into vocal fry and crying when she feels attacked.
I'm talking about now 2023. Let's talk about 2023.
In 23,
Yeah, what about in 2023?
it was the same situation.
Okay, well, I guess I'm a little confused because
Tabby LH $10 for giving me a hearing me out. No, I'm not mad at you. I'm saying I feel bad for you that you haven't been able to get there yet where you enjoy it. But thank you very much. Nothing to apologize for.
So your testimony is that in 2023, and you're saying
Type it
now
out if
under
I may,
oath that
please.
you made no income whatsoever in 2023. Is that what you're saying under oath right now?
I think maybe I don't quite understand what the question is, because it goes back to the LLCs with my family and and just how I'm understanding the question. All I've had has been they've compensated me by paying my expenses, and so it's been the same. So nothing has changed. I just want to make sure I'm answering it correctly, but I'm not sure I am.
Okay. You were asked on the Statement of Financial Affairs to disclose all income, whether it was taxable, that you received from employment or from operating a business or from any source really whatsoever. And that would actually include gifts. You declared 0 for 2023. Is that a truthful statement now that you're sitting here under oath? I just need for you to tell me if that's still a truthful statement.
So here's also why she's extremely stupid. Ma'am, you are already facing criminal charges for perjury. Why are you doing this again? Do you not understand that lying on this, like when you're on the record after you sworn the oath, you more than anyone should know that this has consequences. What are you doing? What are you doing? the Loli Lorne interview. I'll have to look that up. I didn't see your question. If I may, please. If I may, please. Oops.
Hear me out. Hear me out.
Are you referring to, like, if they gave me a certain amount of money, then is that what you're referring to? Because there was nothing, like, tangible like that. They didn't, say, here's $10,000 and that would be income. I mean, like, my bank statements will show it's not like I had anything in there.
Well, I guess I'll have to see your 2023 tax returns.
Oh, yeah.
Did you declare any income at all on your 2023 tax returns?
No, not that I can recall, unless I was saying that my parents, like there was an equivalent to what they were giving me, but I don't think I did that.
Okay, so I'll follow up with that in deposition, but I do need to understand, you're saying that now, but are you aware that what you're saying right now is completely inconsistent with the testimony you gave on?
I thought I handled this the other day. No, he offered it, and I discussed this on the other stream. He offered it, and I said I didn't think it would be a good idea for either of us. So if that's called bailing, I guess. But I said that I corrected the stream when people saying like they thought he wouldn't do the interview. I said, no, yeah, he offered. I turned it down because I don't think it would be good for anyone, me or him. Right. Two questions here. I'm going to back it up because I was reading and I forgot it. Fletcher Boy, her music is available on Spotify and Apple Music. It's not good. Laura Owens music? God, it's going to be awful. Deborah Rockhill, hear me out. My husband has been hearing Lauren streams with me. He now thinks Lauren is an idiot and deserves what the catfish are doing to him. Exactly. He listened to enough and he understands it now. When did he say that, if I may, please? I don't understand. I sent him a clip saying what I had said, so that's weird. Yeah, no problem. If you could see it was on the last Sarah stream we did. But when did he say it bailed? Was it recently? That'd be weird.
No, not that I can recall, unless I was saying that my parents, like there was an equivalent to what they were giving me, but I don't think I did that.
Okay, so I'll follow up with that in deposition, but I do need to understand, you're saying that now, but are you aware that what you're saying right now is completely inconsistent with the testimony you gave under oath in the Owens versus Echard paternity case?
Oh, no. Oh. Don't remind her of that. Jennifer, do you understand how big of a problem that case is already for her?
Are you aware of that?
Yes. Are you referring to? Can you please explain?
More specific? Absolutely. So you were deposed in that paternity case on March 1st, 2024, correct?
Correct.
And in that deposition, you testified under oath that in 2023, you and your mother received about $83,000 of total income from the podcast Nobody Told Me.
Mm-hmm.
You recall testifying to that? Do you recall testifying to that? Yes or no?
Simple question. Do you remember saying that, ma'am?
Yes.
Okay. So was it true when you said it then?
The podcast was making that much money, yes.
Okay. And in that testimony, you said you received half of that. So that's about a little less than $41,000. A little more.
But it was something that, our businesses have been such that we've paid the expenses out of like what's been taken in. So it's gone.
Jesus. Guys, we don't understand. Laura's business is different because it has expenses. Unlike every other business, which has no expenses. Her business had expenses, so there's no income. It's weird that they cling to this theory for so long, even when it's clearly explained to them the difference the first time, and they keep restating it. Buffy Lynn, FYI, Laura purchased HCG hormone shots from the med spa to fake pregnancy test, not Botox. Well, they're both shots. She just misunderstood the question, Buffy Lynn. Come on. That's what she would say. I didn't understand the I'm trying it. I don't know what you want me to say. She's such a liar. I think she's a form of Munchausen. Yes, she does. She views victimhood as something that is much more rewarding than actually being a decent person, right? So that's why she does the fake pregnancy things. She can guilt somebody into something. If I may please, you can only do it on the computer, I believe. Gifting memberships. So she views victimhood as something that is her identity, which I think she will never accept the plea. If she accepts a plea, I will be shocked because there's no way she's going to stand up in court and say, yes, I lied. If she does that, there's going to be a whole lot of hemming and hawing and, well, I didn't mean to lie. I didn't mean to do this. And hopefully she tries that and the judge rejects the plea and they say, we're going to trial. And she's forced to say it because if that was something she was willing to do, she should have done it before she ruined her life dragging on the civil case. It's her identity. As soon as she says, yeah, I lied. I made it up. I agree, I lied. As soon as she says that, her entire image is destroyed. It'd be like destroying herself. That's why she can't plead guilty. Which, again, is weird because the evidence is all out there. This is one of the weird cases where we have all the evidence. It's kind of like Sarah Boone. She recorded killing him. Or Daryl Brooks. We saw him on video running over people.
Right now.
I understand. And so you would say that there was no net income? Is that what you're trying to say?
Yes, we had huge losses from the businesses. Yeah.
Okay. Regardless, on the statement of
and honestly, I don't understand how do you have huge losses from a podcast? If the podcast brought in $83,000, which is ridiculous, what expenses are there for a podcast? Were they renting some super deluxe studio? Were they hiring a bunch of I just don't get it. I don't believe it, for one. But that's a lot of money to blow through for a podcast. Yeah.
Financial Affairs, it told you to disclose all gross income, not net income. And you did not disclose that for 2023.
I'm not sure it made that in 23. I think in
that's what you testified.
23. In 23, I know I testified that, but I was thinking of the previous years. It definitely didn't make that in 23.
No, you dumb. This is what happens when you lie, Laura.
No, you're incorrect. Let me correct you. In 2024, you testified, and the question was posed to you in 2024, how much money did you make from this podcast in 2023? And you testified under oath that in 2023, the podcast generated $83,000 of income, of which you received half. That was your testimony under
oath. What I was entitled to if I needed to touch it or if I needed to do something with it. I mean, again, it comes back to...
So you said you don't get any money. What do you mean you're entitled to? If I need money or... Yeah, Libby, how do you have over $80,000? Well, it's a lot. I mean, you could understand like the Adam Carolla show or like the Pat McAfee show. I could easily understand how the expenses for a production like that, where you've got a bunch of sound engineers, you got the entire place that you've decked out, and you've got all these TV screens and everything. This is a mother and daughter talking to a microphone about stupid shit. How do they have $80,000 in expenses?
I did not understand what the questions were, and I'm trying not to answer anything I
know, correct.
Okay, well, again, I'm going to remind you before we meet again for a deposition that I'm going to have you come to my office.
It's not fake income because Jennifer Giamo sees the disbursement on the mom's bank account. They did get that much money where they split it, but it's just ridiculous.
Here, you might want to consider going over your answers to the Statement of Financial Affairs. I don't know why that shut off. Hold on. Okay. because you're supposed to disclose all gross income from 2023, 2024, and 2025. Also, when you testified at your deposition on March 1st, 2024, you testified that your horse business, and I believe that's Quartet? Was that what the name is?
Yeah, my parents' business is Quartet Farms. I'm a manager of it.
Yes, but you hold yourself out to be the owner of that on LinkedIn, correct?
Yes, as the manager. I mean, like I said, so much of this is just semantics, and I don't know what I'm talking
No, it's not semantics. It's details. It's details. It's not semantics. There's a very big difference between saying you're the owner and an associate or a manager. You chose owner. You listed it.
talking about. And I'm not trying to be dishonest.
Oh, here we go. Here's the waterworks. Here's the waterworks. Back it up 10 seconds from now. Poor Laura.
Yes, but you hold yourself out to be the owner of that on LinkedIn, correct?
As the manager. I mean, like I said, so much of this is just semantics, and I don't know what I'm talking about. And I'm not trying to be dishonest or like hype.
Right, but you understand that what it means. There's a difference between a manager and an owner, and you use.
I didn't know that. I didn't know.
On your LinkedIn profile, you don't know.
I didn't know on my LinkedIn. I didn't know there was a difference between a manager and a member on the LLCs. I didn't know what the difference was.
Right, I'm talking about your LinkedIn profile. You hold yourself out to be an owner of Quartet. Is that not true?
Correct.
Correct what? It's not true that you lied on LinkedIn? Is that correct to say you lied on LinkedIn?
I think I didn't understand what my title was, so I guess technically, but it wasn't something that I'm trying to, it wasn't like I deliberately said that. It's my family's business. I think of it as like my family's company.
All right, well, the question is, you state on your LinkedIn profile that you're an owner of Quartet. Is that true or not?
Then I guess now and I'll change my LinkedIn. I didn't understand.
Ma'am, the problem is not LinkedIn. It was a pointless lie to do on LinkedIn. You were trying to be a big shot, but even then you are probably listed as an owner somewhere. Your parents are doing it so they can avoid some taxes or something.
Okay. So anyway, you testified on March 1st, 2024 that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
That amount was made, but probably $400,000 in losses.
God. Stop saying what your losses were. It doesn't matter. Gross income.
Okay, that's not what I'm asking. You gotta listen to my questions. I asked you, do you recall
You got to listen to the questions, Laura.
testifying that you and your mother split $144,000 of gross income that was generated from the horse business in 2023?
I mean, I don't feel like I'm answering these questions the correct way. I mean, it's just that
The only correct way, Miss Owens,
business's bank account, it like didn't go to me directly, yeah.
the only correct way for you to answer is honestly. Okay, so
But that's what I'm trying to do is answer as honestly as I can. And I don't know a lot of the stuff that you're asking me, the answers to that my family's businesses, and I don't know.
Okay. Well, that is what you
No. It's the painting and the puzzles. Get the painting and the puzzles. Come on.
That you're asking me the answers to that my family's businesses, and I don't know.
No.
Well, that is what you testified
So pathetic. What are you, a 4-year-old?
to under oath in your deposition in the paternity suit, so we'll have to deal with that later, but that is extremely at odds with what you testified to under oath in your pleadings in this case.
Correct, because I presume that was like what my equivalent would be in terms of what I had done and brought in for work.
Okay. The other testimony you gave, which is
Ma'am, you are already facing charges in the testimony from that case. Stop lying.
actually at trial in front of a judge on June 10th, 2024, you testified in front of a judge that you were, at the time of trial, 2024, making $200,000 a year approximately. Do you recall that testimony?
Yeah, I remember you saying that. $200,000. All right, Laura, how are you going to handle this? 1 second here. Pause. John Williams. Polynomial purebred $4.99. Thank you very much. Also on her LinkedIn, proud grad of the Amber Heard School of Business. Well, I'd say the Amber Heard School of Acting, because she's almost as bad as Amber Heard is. Eminem and Emily, $10. Late to the party because I was watching King of the Hill with Hubs. The new season is thumbs up, but we'll have to replay crew because house cleaners super early in the AM. Peace, love, and good dreams to all. Well, thank you very much, Eminem and Emily. Eminem and Emily. It's the most pathetic fake crying. This is a bankruptcy hearing, ma'am. You're not recalling some violent attack or something.
Correct, yeah.
And now, is that truthful testimony?
Oh, that's a trigger word. Truthful testimony. I can understand why she's crying now.
I'm not comfortable answering that now that I realize how much I have messed up my other answers, and I want to speak to an attorney before I answer.
Ma'am, you're going to have to get an attorney for this hearing now? You want to speak? You're going to plead the fifth in your bankruptcy hearing?
Because I genuinely don't know how I'm trying to explain that income has been split up in my family.
Yeah, you're doing it poorly. You are failing miserably at this. Or we all know, we can all hear it. The problem is you can't lie well because you're stupid.
Okay, I'm just asking if at trial you testified in front of the judge that at the time you were making about $200,000 a year. And I'm just asking if that was true.
Yeah, that was exactly what I thought at the time. I mean, I know what the business is generated, so.
But you didn't report that on your bankruptcy, your sworn bankruptcy statement.
But that's what our family's business is generated, and I have been like the face of the business, is doing a lot of the work, so.
Shut the up at this point, Laura.
That's why I said that amount. I mean, I still know that was consistent with what they made, and that's why I said that amount.
Okay. Well,
Why?
Again, we'll have to delve into this more in a deeper way when you come here for a deposition. So are any of the entities, well, let me just go by each one. Quartet, is that still operating?
Yes.
And is Lizmax still operating?
No, that needs to be closed officially, but it's not. Property is forfeited.
What about Keybacker? Is that still?
Well, why would Lizmax matter, man? Because you said you transferred it over to your mother. So why do you even list it there? Unless you're trying... It's none of this makes sense. To the most basic line of questioning. This is probably why she withdrew her bankruptcy petition after this, agreeing to not do it for another year, and they was granted because she hasn't asked for any protections that she's received yet. So therefore, they let her withdraw, rather than they're like, yeah, she's going to be perjuring herself again. But parents are in a much worse position.
Operating?
No.
And Stylee was never operating, correct?
No.
All right, so, but Quartet, and that's the wholesaling business? Mm-hmm. Yes?
Yes.
Yeah, selling Frosted Flakes. That's the worst. Rolling on still, if I may please, you think she'd be better at the fake crying by now? It's pathetic. I mean, her crying, remember the Facebook, there's some classic videos for out there where she's like, on Facebook, and then she's like, oh, it's meant for only my private family members. Yet you put it public. How do you screw that up? And why are you telling them things that they would already know? Like, my name's Laura Owens. Your family knows who you are. Your family and friends know who you are. You don't need to announce your name, you dumb. Your lies are so bad. Oh, it keeps hitting the button here. Sorry, I'm not. Sorry.
And that's still operating?
Yes.
And do you still work for that entity?
That entity is not doing anything actively right now.
All right, so you're saying that these businesses, these LLCs, there were no tax returns filed individually on behalf of them, or was there or no?
Lizmax, yes. The other ones, The other two you said were Keybacker and Stiley. Is that correct?
Yes.
Oh, Miagarita, have you not heard this before? Interesting. Yeah, this is another level of stupid. They're not as dumb as Lauren, right? Because they know when to, like, they know that the truth is going to be a problem for them. Lauren goes ahead and makes up an answer he thinks clears everything up, which just makes it worse.
No, there were no tax returns. Those never got off the ground.
What about Quartet?
Quartet, my parents file on their Schedule C.
Okay. So your parents are the ones that file on their Schedule C. They have the income Quartet flow through to them on their own tax returns. Is that what you're saying?
And nobody told me LLC.
Okay. Okay. I just have three more questions. So during the paternity action in the state court, you did testify in an affidavit that you had almost $450,000 of cash in a checking account. Do you remember stating that under oath in an affidavit in the paternity suit?
See, now, this is who we should be hooking Lauren up with. Laura Owens. She desperately wants a man. He desperately wants to have a baby. They're both liars. They would just lie to each other all the time. Matt Calloway, welcome as a new member. Lou said, I tried to tell my dad the basics of the story, and he kept stopping me, saying that can't be true. How did that happen, etc. He couldn't believe people would act like this. Yeah, I mean, her being prosecuted for perjury is exactly appropriate because she will never stop. She will never stop. Even when she goes to jail, she would rather go to jail than admit that she lied. Because even going to jail, she could still embrace victimhood, if that makes sense. She could be in jail the entire time saying they lied. It was the online smear campaign. They sent me to jail because I got pregnant by the Bachelor. She can embrace that. It's not like she's really doing anything anyway, right? She lives in the casita. She doesn't have a job. So I hope they ring her up for the max, right? When she keeps denying that she lied, it's the only thing that will probably never help her. It'll probably never help her, but it should maybe give some more intelligent people pause. Yeah, I if I may please, I feel like you're missing like half the stuff that I'm saying on here. I gave the option of the Jeremy DeWitt phone calls or Sarah phone calls last time. I know Jeremy DeWitt very well.
Three more questions.
And strangely enough, here's a nice connection. I just realized today, Jeremy DeWitt was sentenced by Kranick. And he maxed him out on it. On his failure to register a vehicle as a sex offender. Gave him the 87 months. Hit him for the max. For failing to register a vehicle. Kranick wasn't having any of it. He's like, yeah, you have a well-documented history of felonies. For real? Yeah. No, Kranick sentenced Jeremy DeWitt twice, because he had two different cases. He had the first one, failure to register the vehicle, and then he got hit up for insurance scams problem, but then they ran concurrently to each other. But two separate cases, and he rang them both up. Yes, Kranick. And I saw people in the comments, because this was like a year ago. I found the video through Reddit, and people in the comments were like, "Oh, it almost feels like the judge believed him half the time," which is discouraging. And then I was like, "No, they don't know Kranick. Kranick is just going, okay, all right, I've heard what you said, and I've taken into account there is no reason to downward departure, and sentence you to 87 months." No updates on Lauren yet, though. Deborah.
So during the paternity action in the state court, you did testify in an affidavit that you had almost $450,000 of cash in a checking account. Do you remember stating that under oath?
So this one, I'm going to call this lie where she's, how she said she attached proof of funds. I'm going to rate this less of no, it's still a lie. It's still a lie. what I'm saying is I could see the semantics of saying like I have $450,000 available to invest, but then when she gives the specific language here, it's really clear that it's another lie. Because she was trying to, for those who don't know, she was trying to sue Clayton Echard for the fact that he didn't put in the bids after she freaked him out and said, "Hey, I'm pregnant," and then sent him like 100 text messages. And he's like, "I can't. You didn't get pregnant from me. We never had sex." She's like, I think everyone here knows about her, right? Where she's like, "If you agree to date me, then I'll have an abortion if you agree to date me. But if you don't, I'm having the babies." Kentu Sukure, somebody help out Kentu Sukure in the chat. Everyone fill her in on who this crazy is. She's on a Sarah level of delusion. Possibly worse, because she could have stopped doing this at any point, and she didn't. What was I saying? Yeah, she tried to sue Clayton, saying, "Oh, you didn't do your due diligence." Oh, she put in a complaint to the real estate board or something like, "He didn't turn in my offers when I showed I very clearly had the money, and I would like a settlement of $1.2 million, or you could drop this case."
In an affidavit in the paternity suit?
That was a misunderstanding with my attorney. So I was going to buy property with the defendant on that, and he knew that I was going to be borrowing the down payment from an investor who he had spoken to using this method called the Morphy method, but Clayton admitted under his deposition that he spoke to the guy, and the guy had $450,000 in a money market account, and
if that's where it ended, you would be fine, but you went beyond that, didn't you, ma'am?
That's the proof of funds he submitted. It was never mine, and Clayton knew it was never mine.
Okay, so are you talking about Gail Lynn Rich? Is that the investor that you're referring to?
I don't know who that is.
Well, attached to your affidavit,
it was a man named Matt Bentley, and it was his mother-in-law. That could have been what her name was. That definitely could have been her name.
okay, so because you attached a copy of this money market checking account statement to your affidavit claiming, and you admitted in your affidavit that you attached, and I'm quoting your affidavit now, "I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account as shown below."
Yeah, see, then you went there, Laura. You were fine until you brought this language into it.
And then there's an excerpt of that money market account. That's your affidavit.
So David was my civil attorney, and that was his error, and he will explain that if you have any questions. But that
well, I understand that, Miss.
Jennifer Cottrell, no, it's not a problem suggesting the podcast for the summary. I've seen a couple good ones out there. I am trying to, I got so many things going. Like, I did want to actually do my version of what I always thought would be easiest to understand with the timeline showing on a different route where things changed. I guess I thought maybe like if the court case was going forward with the trial, that'd be helpful. But I think visually it helps to explain because it's so obvious the lies of where stuff shifts and stuff disappears or appears. But yeah, I don't have a problem as long as they don't click off as long as I don't click off.
But you're the one who signed it under oath.
I didn't read it carefully enough, and as I said, Clayton deposed the fact that he's the one who submitted the proof of funds. He got that information. He knew it was never mine.
Okay.
If somebody knows of a really good summary, like a 1 hour summary podcast or something, to introduce people or catch people up on it, email me the link, and then I will put it in the description of this video so people can see it. Like, you know what I mean? And then for future viewers, look in the description of this video. You'll find the link, or I can put it on the next one as well. Bye, Joe Kate.
So
No, it's fine. I don't get mad about people doing that shit.
Or that further too. Okay, then what's the name?
I mean, if you have another question about it, I'm happy to answer it.
No, you aren't. Your answers suck, Laura. You need to stop talking.
Well, my question is, when you made that statement
Okay, I get it, Joe Kate. Yeah, okay, I get it. I get it. Good one. You got me good.
in your affidavit, I attached proof of funds to the offers, which included a current bank statement showing I had almost $450,000 in cash in my checking account. Was that a false statement?
Yes, it was. Laura, here's the hint. It's false based on what you just said 2 minutes ago, that it wasn't in your bank account. It wasn't yours. And you said under oath that it was in your bank account. So that's a false statement. Just say, yes, it was. Come on.
I didn't write that. It's David.
Yeah, here we go. Remember the beginning when the judge asked her, hey, did you sign all of these documents yourself? And she's like, yep.
I mean, David signed it. David was my attorney. David signed the pleading.
Well, you understand that when you sign an affidavit swearing under penalty of perjury that it's truthful, there's consequence to that. You are testing under oath and subject to penalty of perjury that is a truthful statement.
I mean, it's so ridiculous. The fact that Jennifer keeps bringing up perjury, and she has to know about the criminal case, right? But the fact perjury should register in this woman's brain more than anyone else in America. Perjury. Oh yeah, perjury is a problem. I don't want to keep getting dinged for perjury.
Are you saying that's not truthful now?
The $450,000 was not my error. David will take that. That was not my. He signed that affidavit for me. I didn't sign that. I mean.
Oh my God, this is probably the lamest excuse. First off, did David write it and sign it for you? Is that what you're saying? Because I'd be pretty pissed if I was David, but you know, then again, David doesn't really have any scruples or morals, whatever. But if you give your lawyer permission to sign stuff for you electronically, it's still on you. And plus, you said you signed it all yourself at the beginning of this hearing. This is another lie.
He knew that wasn't my amount of. He knows that. I mean.
You're denying that you signed the affidavit.
If I may, please. She's Googling the definition of perjury, and the first result is her face on Google. Take that, Laura. Take that.
David, I have a copy of it in front of me showing your signature.
I believe David had a copy on hand of my signature, and yes.
You authorized him to sign for you, correct?
Yeah, I guess that would be what it is.
Well, you're not accusing him of forging your signature, are you?
No.
Okay, so...
No. I'm not accusing him of faking my signature. What I'm accusing him of is lying on the form and then using my signature to put it there. And so I'm not responsible for it. That's all I'm doing. Come on.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
Yes, yeah. I guess.
Okay, two more questions. Just, can you...
I honestly don't know if he knows that Robin the Eater Pro. How well do you know Gingras? He's the worst of the worst I've ever seen in terms of, like, I just sees somebody, and I know there's a whole vigorous defense, but like, he goes so far beyond vigorous defense, being like, how is this guy not brought up on ethics charges?
Tell me the nature of the Owens versus Maricini lawsuit, which is currently on appeal. What's the nature of that suit?
It's a domestic violence restraining order lawsuit.
Okay, that you had filed against this defendant, Maricini?
Yes.
And did you seek damages?
Were you lied?
Any kind of recovery in that lawsuit?
No.
It was just a restraining order?
I know he has been now with the Arizona State Bar, but I'm saying way back then in 2024, I was like, how is this guy just not rung up already? How is he not rung up?
Yeah.
Okay, and then, and it says it's on appeal. Who filed an appeal?
I appealed it.
Okay, when did you file the appeal?
I think it was like December 5th.
And that's another reason she's terrible or dangerous, right? She won't let Marriage Sheedy rest in peace. She's filing an appeal now that he finally got released from her torture. I want an appeal. I need the restraining order. This is a public service announcement for all my audience because you're all very intelligent. If anyone you meet or a potential romantic partner has a restraining order issued against more than one person, run the away, because there's no way that this person is so irresistible that they have two people stalking them. Okay?
I'm pretty sure.
And how did you get the money to pay for an appeal, to pay for appeal attorney and all the costs associated with an appeal?
This is her face.
I don't have an appellate attorney, and my fees were waived by the court because of my income.
Okay, so you haven't paid any kind of fees in connection with that appeal?
No.
And
She doesn't make women look bad. She makes crazy people look bad. I've never once looked at Laura Owen and been like, oh, women. Just like I don't look at Lauren and be like, oh, men, right? This person is crazy.
you are appealing a decision that denied you this restraining order?
It got dismissed because I was in the hospital and I'm on the day of the hearing. So, yeah.
And what's the nature of the Owens versus Gillespie lawsuit that concluded in Maricopa County?
Yeah, this is a hot one. Listen to this. Listen to this reason. What is the nature of this lawsuit versus Gillespie, the guy before Echard, that she also said she had? She said she was pregnant with twins with Maricini, with Gillespie, and Echard. Always twins. Why is it always twins?
That was a civil case that I filed.
And what was the nature of that suit? What was the claim?
Abortion coercion was the claim.
Well, that's because you're an idiot.
First off, you didn't have an because you weren't pregnant. Second, coercion. The text messages in that case read so badly for you, Sarah, or Laura, not Sarah. Like, I'm going to take the pill. And then she's like, I took one pill. They told me I had to take 2 pills for the twins, but I only took 1 pill. So one of them disappeared. Like, just dumb ass shit.
And were you seeking damages to recover any money in that case?
I was seeking damages, and at one point I asked that they be made to a charity, to a women's charity.
And there we have it. The Amber Heard comes full circle. She's like, I wanted nothing. Right, Amber. Virtual signaling from the stand. Oh, I was suing him and I wanted it to be donated to a charity. Like, it's so transparent. Don't even try. I don't know why people even try this anymore. It's so nakedly manipulative, a manipulation tactic. It means you're going to get more people that don't have an opinion believing you're full of shit. Once you say that, then you will convince that you're good. Paternity testing can't be done for twins while pregnant. Well, A, she was never pregnant. But B, she said after like 10 days, she's like, yeah, it's a boy and a girl.
Was judgment entered in your favor?
No, nobody ended up getting anything.
How was it resolved? Was it case dismissed or was there a trial?
He filed a counterclaim and it was dismissed on both sides.
Somebody's got their phone on.
Yeah, I can't.
I think it's 602, whatever that number is, I can see. You can see. Somebody, please mute your phones. Thank you. I'm sorry, Miss Owens. Can you just so basically, I just wanted to know how that was resolved. Did it go to trial? Was it dismissed? What happened with that case?
It ended up being dismissed. I think they maybe my side and his side. He filed counterclaims, but neither of us ended up getting anything at the end of the day.
Okay. All right, that's all I have. I very much appreciate you answering my questions, and Mr. Haley, thank you for allowing me to take up so much time to ask these questions. But just to be clear, Ms. Owens, I do intend to have, I will be asking you formally for documents, which will include those bank statements, and
Yeah, this doesn't sound good, Laura.
I will be asking you to come into my office here in downtown Phoenix for a deposition.
right, so that's the end of that. We're going to move on to Owens' parents' bankruptcy hearing. So a little bit of background on this. It will be covered in this hearing. It'll be explained. But they tried to file for Chapter 13 in 2025, like May 2025. I'll back it up. At the end of 2024, they started a GoFundMe where they cited, Ron, he's had all these health issues and, it's taken a toll on us financially and emotionally. And so, if you have anything, and they raised like $140,000. And their story is like, we're using it to try and avoid bankruptcy. And then they tried filing for Chapter 13 bankruptcy. That ended up being dismissed because they, A, didn't provide the financial documents they needed to. B, they stopped making the payments they were required to. And I don't remember what the third one is. It'll be covered in here. But now they are back and they're filed Chapter 11 on their own. And it is so bizarre that I think they've even said it here where they're trying to withdraw it. What is with the Owens and filing something and then trying to withdraw it immediately? Like, did they not learn anything from Laura? Laura filed the paternity suit against Clayton Echard, and then when she realized, oh shit, this keeps going, they're really gonna they're gonna make me prove that I was pregnant, and this ain't gonna go anywhere, and I want to withdraw it. I want to withdraw my case, and the judge is like, no, you can't just do that. We're gonna hear this out. Same thing is happening here. They're like, we want to withdraw this Chapter 11 one because this is a lot harder. We always, that's the other thing they keep saying. They're always like, we were seeking the help of an attorney, but we were unable to secure one. But here we go. This is about a half hour. This is the last one we'll do for this part 1. There's going to be part 2 and 3, 4, right? I mean, because there's a couple hours of this stuff. But yeah, remember, hit the like button if you're here and you're still here enjoying this, and sub if you're not. But hello, Muddy May. So this is June 18th, 2026. And I like my little thumbnail that I've got here. So this is her parents. Ron Owens, the ex-radio DJ in San Francisco, and then his wife, Laura's mom, Jan Black / Elizabeth Naylor. She can't even commit to a single name. And they're totally not batshit crazy. Laura looking over their shoulder it just sends me.
My case 26-05144, Elizabeth Naylor and Ronald Owens.
I'll take the appearances in the Naylor and Owens matter.
Good morning, Your Honor. I'm Elizabeth Ann Naylor, appearing pro se, and my husband and co-debtor Ronald Stephen Owens is also present with me today representing himself.
All right, thank you for your...
I guess this should be the time to mention these people received like $21,000 a month in their pension and Social Security. $21,000 is their income, and they're blowing it all on their stupid daughter and whatever else they've got going on. Yeah. One thing I'm also looking for is everyone's seen Twin Pregnancy Hat Trick. I did another song that was more heavy metal it was in response to something she wrote on Medium. I'm trying to find that, so maybe once I find it, we can intersplice it here. But yeah, now we're on to the parents. Okay, here we go. Yes, pension is $14,000, and then their Social Security, it's $21,000 a month essentially. Ridiculous! They can't afford their bills.
Appearance, ma'am. And
good morning, Your Honor, Jennifer Giaimo on behalf of the United States Trustee, and thank you for allowing me to appear by Zoom because I am out of town.
Oh no, Jennifer Giaimo's back. Oh no! Woman will not leave the Owens alone. It's the online smear campaign.
All right, thank you. Good morning. Any other appearances? No. All right. We've just called the Naylor and Owens matter. Counsel, if you'd like to make an appearance in that matter. Okay. All right. Let's go ahead and proceed. All right. So, Ms. Naylor and Mr. Owens, this is your emergency motion to extend the automatic stay in this case. As you are aware from preparing the papers, the automatic stay will expire shortly unless the court finds that grounds exist to find and conclude that you have met your burden of establishing clear and convincing evidence and able to enable this case to move forward. I did want to clarify a couple of things for you, Ms. Naylor and Mr. Owens. Just some of the statements you made were that U.S. trustee hadn't proven bad faith, but that's not really their burden. It's your burden to prove that this case was filed in good faith, and you have to have clear and convincing evidence.
I'm sorry, I just listened to the Sun Ho song in the background, and I forgot how epic it is. I'm going to try to work on it.
Another thing I also wanted to advise you is that the court's mortgage modification program is not mandatory. It is a program that can be administered through this court. The creditor, however, is not compelled to participate. When they do participate, of course, there's a requirement to appear and to participate in good faith. But the process is that you request to be in the program, and the creditor can ask to be removed from the program. So I did want to clarify for you that is not something that the court can require the creditor on your home to do, to participate. Okay. Did you have a question about that?
No.
Okay. All right. So this is your emergency motion to extend the automatic stay. The primary thing that the court is looking at is what has changed between when you when your first case was dismissed and the filing of your new case. That's really all I'm concerned with. What is your change of circumstances, and what can you tell me to show that this case can move forward successfully? So you've told me a lot of information about your dealings with the creditor, about your, you've indicated that your income is steady, but I can't tell that has been a change from your prior case and when it was dismissed. So why don't you focus on that information?
Well, the prior 13 was dismissed not because we abandoned it, but because our attorney didn't act.
Ma'am, you're talking to a judge. She knows when you're lying. What are you doing? Why are you starting with this? This is the moment I knew, like mother, like daughter. This is so embarrassing. Such a bad lie. Go ahead. Throw the lawyer under the bus.
When I asked him to in writing.
Well, let me just stop and interrupt you there, because I've reviewed the papers filed in the prior case, and the reason your case was dismissed is because you did not turn over to the trustee tax returns, and because your plan payments were delinquent. And I believe, and also you had outstanding objections to confirmation that were unresolved.
All right, so you didn't file the returns, you stopped making the payments, and you had outstanding objections. That's why you got your bankruptcy denied. Idiots! This is not a good way to start in front of the new judge while you're trying to convince them that something else is different that your paperwork doesn't support, and you're trying to go like, yeah, just trust me, bro.
So whatever may have happened with your attorney, that I don't know what happened there, but filing your taxes and turning over your returns and paying your plan payments are all within your control. Correct.
And as far as the tax filing is concerned, we have had major health issues with my husband I'm his primary caretaker. And I had not filed the taxes because I knew we didn't owe anything at that point, and I had other issues that I was taking care of. And then when we filed for bankruptcy and I wanted to get the taxes filed, I was unaware that when you file for bankruptcy, the credit card companies make it so that you no longer have access online to the prior credit card info.
I don't know if that's true at all. If you call up and cancel your account, probably, maybe, but I don't believe this
information. So I didn't.
Why is the credit card information something you're telling me about?
to the purposes of deductions and expenses. I had relied on those being available online. So we have since filed the returns for 23 and 24 that were asked for. And so those have been taken care of. As far as the plan payment is concerned, we had some major unexpected expenses that could not be put off. We had major storm damage and cleanup that had been required, and we had septic tank issues, and we had car repair issues, and the money had to go into those things from an emergency crisis standpoint. Going forward, we would anticipate that the amount of income that we have that is guaranteed, the $21,000 a month income that is guaranteed under our Social Security and pension benefits, would be enough to give us the restart that we need here. And also, as far as the payments are concerned, in dealing with SPS, they would send me information that indicated that the entire amount of arrears had to be paid at a time, that it wasn't like you can just make a one monthly payment, that the whole thing needed to be paid. So it seemed like until we could actually talk to SPS and get things clarified with SPS, it didn't seem to make sense to throw money there when they would have the home in foreclosure anyhow.
So let me go back to my question for you, which is, what has changed in your personal and financial situation since the dismissal of the first case and the filing of the second case? Because the guaranteed income you've just mentioned, the $21,000, that was in fact part of the first case. So that's not a change. So what has changed?
Correct. So we also had some expenses with two of the LLCs that we have that are no longer applicable. And so that is a big burden that is off the table.
Could you be more specific?
We had one LLC that had that was an investment in a short-term rental that we had to forfeit. We had expenses, major expenses with that, and we had bookings that were down from that. We also had.
So wait a minute before you move on. I guess I don't understand. Your papers didn't tell me anything about whatever it is you were just mentioning. Bookings with rental property.
Liz Max Investments. I believe it was listed as zero value in that.
Well, I mean,
just call it lying Max. It works better.
Your motion to extend the stay didn't describe.
And I realized you probably heard some music in the background, maybe faintly. Sorry about that. Ravina Denver is lost on what we're talking about. People try and fill in Ravina Denver on who this bad crazy person is. This is a bankruptcy that is adjacent to a completely crazy case of lying and trying to extort Clayton Echard, the Bachelor, and this woman is up for perjury charges. The one that's over to the side here, peeking up from behind her parents. We're reviewing it to see how similar her bullshit is to her parents' bullshit.
Describe a change of circumstances involving.
Yeah, and I know I do have the label back there that they're totally not batshit crazy, but they are.
What you've just mentioned. So are you saying that you had some real property that you have surrendered in the interim?
Everyone help out chat. Help out Hope, Case Camp, help out Ravina Denver. If you don't know who Laura Owens is, help out. Just describe who Laura Owens is, and then we'll explain the bankruptcy stuff in addition to that.
Period? Yes. So it was an investment that was costing us money, and as I say, it's listed as Liz Max Investments on there.
Like a great investment.
Okay, so one of the struggles that I'm having in preparing for this hearing, and let me roll back for a moment and just say that the papers you filed are not acceptable in terms of being too lengthy. You cannot file 29-page responses. We have rules about how long papers can be. In some courts,
the saddest part is, that those 29 pages, like one of them was maybe, it was like 1 page worth of information. Sounds exactly like a Sarah motion. It's just a bunch of bullshit.
the court will literally take the filing you have filed, find the page limit, rip it off and throw it away. I did not do that. I read your papers, but in the future I'm not going to. So your motion and your reply were both too lengthy. But the problem is, I don't have schedules and statements in this case. You've received an extension of time to file those, which was good. I'm glad that you got court authorization to file those papers later. The problem is that they're due at a date that beyond this hearing. So as I'm preparing for your hearing today and reviewing your papers, I still don't have the schedules and statements that you need to prepare under penalty of perjury so that I can really understand the changes. So for example, you just talked about surrendering a parcel of real property. That was not disclosed anywhere in the papers that I've reviewed today. So I'm a little bit struggling to fully understand your situation. Let me move on and ask you, what other changes have you occurred? So you've surrendered a parcel of real property. What else has occurred?
We had some companies that were part of our LLC, our Quartet Farms LLC, which we no longer have, and which were costing
Frosted Flakes?
Quite a bit of.
Frosted Flakes the pony? Has anyone helped out chat here? Of
money monthly on board in Florida.
I have a comparison of how it work here. All right, if you're familiar with, for those who don't know who Laura Owens is, if you're familiar with Jeremy DeWitt, Jeremy DeWitt would be ancillary to Lauren if Lauren had a job and wanted to be a police officer, impersonated them forever, and got arrested impersonating a police officer. Totally unnecessary doing it and racking up chance after chance to not be arrested. Okay, so now take Sarah Boone, and now we compare it to Laura Owens. Sarah Boone did the one crime. She's in prison for life because she can't accept her her responsibility that she killed somebody. Laura Owens instead convinced or kept telling men for years, or maybe a decade, that she was pregnant by them, and then she'd say, we need to date. I want a dating contract, and like when she told Clayton Echard that she was pregnant with his twins, despite the fact that they never had sex, she said, I will abort them if you promise to date me. But if you're not going to date me, I'm having the kids. Like, just crazy, next level crazy. And this whole family is little scam artists. So they're trying to do bankruptcy in conjunction with it, because she needs to do a bankruptcy because she lost the case against Clayton Echard, and she owes like $200,000. And her parents keep funneling money to her and her kids, and they're trying to save their house with basically, let's just we want everything wiped clean, but they don't provide any actual documents because they make $21,000 a month in terms of pension and Social Security trying to declare bankruptcy. The real answer is they paid for her criminal, because she's being brought up on perjury charges in Arizona. That's how much this woman lies. She's actually going to trial on perjury charges from the civil cases because she's that bad. Okay, so hopefully that helps.
And we no longer have those.
So what is that you said, that property? Was it personal property? Was it real property?
It wasn't. It's not a property that we own. I'm saying that they were boarded in Florida.
What was boarded?
The ponies.
You had ponies boarded in Florida, and you no longer own those ponies?
Well, one
of them is
Frosted Flakes. I just love saying Frosted Flakes. Frosted Flakes?
Hear me out.
One of them was sold, and one of them is leased out.
She lied so badly. That's the epic level of lying this woman did, and we have it. We've seen it. The evidence is out there. It's all on video. She did it all in emails to people, and she did it on video with the court. She lied over and over. They weren't even good lies.
For the year.
Okay.
That's, yeah.
All right. I'm not going to be able to to consider your emergency motion today until I receive your schedules and statements with full disclosures about what has happened in this case. I think what I will do is I'll hear briefly from Ms. Giamo, and then I'm inclined to give you a short continuance until after the schedules and statements have been prepared and filed so that I can review in writing your situation and I can have a better understanding as to what has changed between the dismissal of the prior case and the filing of this case.
Nothing.
But let me ask you this question. Your papers indicated you were looking for counsel. Your case was filed nearly a month ago on May 22nd. So where are you with respect to obtaining counsel?
Buffy Lynn, 499. You could read Clayton's pleadings in paternity case and judges willing to give people a good overview, or I'm sure Megan or Laura know of a summary. Yeah, Laura Knighty, she's covered this case since basically she's followed as long as I have, at least. Yeah, okay, so they need to give a status update on the lawyer, but we're going to listen to this song. It's not polished at all. I'm sure it cuts off. This was after she lost the case against Clayton and then was recommended for perjury charges. And she just went off again in another article, not learning any lesson of like, hey, I should pump the brakes on what I'm doing because this could get really bad for me. And so I just imagined in my head, like as I always do, like with the demon statement for Sarah Boone, like I just had this idea in my head, and I did this kind of on the quick, but it's even if you don't like death metal or new metal, look at the words on the screen. It's kind of karaoke style. My name is Laura. Oops, let me try to make it a little bigger. Yeah, you're gonna have to look really close here. Sorry. Maybe actually I'll re-render it with the bigger video. But yeah, cancel it. Okay, well just keep watching this and I'll get it bigger.
I have spoken with 21 different bankruptcy firms and attorneys.
And
a lot of them are busy and unable to take the case. I have found one who is willing to take the case. However, because we ended up having to file pro se at the last minute, my understanding is that the post-petition, that the retainer fee post-petition has to be paid by a third party. So we are in the process of finding a third party to fund the retainer. And then the attorney has told me he would be happy to step in at that point, but that it has to be funded by a third party.
What is the name of the attorney you intend to hire?
Garaman Yusufov.
George Glass. George Glass.
And when do you anticipate hiring Mr. Yusufov?
Just as soon as I can find the third party.
So you don't have that lined up yet?
I am, it was not something I was anticipating.
Yeah, this whole epic case goes back to, was the end of end of 2023. Q4 2023 is when I first saw it from Law Talk with Mike, and it just ballooned from there.
Have to do so. I'm reaching out to friends and hopefully we'll have something set this weekend so that he could come on board early next week.
All right, shut up, Jen. Here we go. This is the song is called "No One Ever Told Me Lying in Court Was Perjury." All right. And this is the earlier version of Sono, so the vocals aren't as easy to understand, but you can look on screen and hopefully it gets most of the typos right. But just imagine this woman filled with rage singing this song. My name is Laura Owens. Some question of pregnancy from blowing. I've been a master who I really am. My final quest is to destroy everyone I can. Moved in secrecy for years. Success That's LA planned pregnancy. LAPP is Los Angeles planned pregnancy, which was another whopper of a lie. She in court suddenly said, "No, I went to Los Angeles Planned Parenthood to get my sonogram." Well, the Los Angeles Planned Parenthood office is closed on Sundays. All right, here we go. But is it really lying to lie about lying anyways?
Lies a medium. There's always a chance an idiot could believe them. I'm done playing nice, no more pretend. My chaos here will never end. I will destroy the world in a century's face. Forever telling lies and the best turtles I never face. I'm starting on your videos with impunity. An army of mortals with souls is no match for me. No one ever told me that they lying for his perjury. But is it really lying to say I never lied about losing an ovary? You challenge me and never pay, because I am never fucking going away. No one ever told me LAPP is closed on Sundays. But is it really lying to lie about lying anyways? You dare challenge me and never pay, because I am never ever fucking going away.
That is just a weird sound. She is being held accountable. She's currently facing 14 charges of perjury and presenting false statements or fabricating evidence. I think like 12 of them were felonies. She just got a continuation yesterday or the day before for another 90 days. There's a plea offer out there, but she'll never take it because she's crazy. But yeah. No, there's another guy, Mike Maricini. She mentioned him earlier. Oops.
And I know the amended schedules are due on the 26th, and that the 341 meeting is on the 30th.
And so do you intend to retain Mr. Yusufov to attend to complete your schedules due on the 26th?
I would like to. If that timing doesn't work out, then I am committed to this.
Sono's better now, so I might try and run it through again with the updated thing if I can get it to produce the same music. I like the music and the harmonies. I ran it, like I said, I was blowing through Sono credits. It took me like 20 tries to get what I wanted in terms of a chorus. No, they don't oppose. Why would the state oppose? Yeah, go ahead. We'll do another continuance. It shows how long you are not accepting this deal. So when you don't accept the deal or you're convicted, you're going to get rung up.
We are committed to this.
All right. As I indicated, I'm inclined to give a short continuance of this matter and impose a temporary stay under Section 105 because the 30-day period of your bank from the filing of your case is looming, which means that the automatic stay under 362 is about to expire. And I will say that on this record, I do not have clear and convincing evidence that there has been a change of circumstances. But let me turn to Ms. Giamo and hear from her briefly, Ms. Giamo, since you know pretty much what I'm going to do here. Thank you.
Thank you, Your Honor. Yes, thank you. Well, the first thing I want to point out is that, you know, Your Honor said that you don't have the schedules and statements, but we do. We actually do have schedules.
Our hero, Jen, steps into the ring again. So as I mentioned earlier, some of you might not have been here to see it. The problem with them trying to withdraw this kind of stuff is because they've already used the protections of bankruptcy filing to say, hey, you can't take our house. And now they're saying, oh, now we're going to withdraw it. And, you know, we're trying to get our own lawyer. And, you know, they basically just want a pause on their foreclosure without having to disclose their financial information.
statements that were filed at docket 9 in the case, and that's a large part of the U.S. trustee's objection.
They think this is a game, and they think they can convince anyone of anything. They can't.
The fact that there's huge misrepresentations in there. This is not.
And you were correct. I'm sorry. Let me interrupt and just say there are scheduled statements. They are in the debtor's term skeletal, which is essentially non-existent. So, and my apologies, but for the record, I will concede something was filed.
Thank you. And actually, I would definitely disagree with their claim that this was a skeletal petition. As Your Honor knows, many debtors file a petition, but they don't file schedules and statements, and they end up asking for an extension of time to file them. That's not what happened here. Mr. and Mrs. Owens, what they chose to do was file schedules and statements that were false. And that's just another indicator of their bad faith. And that they would choose to file schedules and statements knowing that they were signing them under penalty of perjury and knowing that they contained false statements. They should not have filed anything. Or if at the very least, they could have left everything blank, but they didn't.
Well, so they just wanted to get through.
Point out that that's a very key thing. And the other thing is, Your Honor, my understanding is that the court's decision has to be made before the 22nd. Or once the stay terminates, that's it. So I don't know when Your Honor wants to reset this hearing for, but I would argue that you have sufficient grounds before you right now to deny this motion because, as Your Honor pointed out, there is no clear and convincing evidence. There's no evidence at all in this case that there's been a change of circumstances. There were no change of circumstances that were listed in the motion, and there were none that were listed in the reply after I specifically pointed out in our objection that they needed to show that. There is no change in circumstance. And they will not be able to show that unless there's going to be more misrepresentation and there's going to be more inconsistencies between the various sworn statements they make. And I just don't think that these debtors should have another opportunity to make more false representations under oath to this court. I think the time is now to say what I have on the record is sufficient to show that they have not, to show that the case was filed in bad faith. First, because there's a presumption of bad faith, because there's no change in circumstance. And second, because of all the reasons the U.S. trustee outlined in her objection, which is that there's a lot of evidence here of misrepresentations, egregious conduct. I want to address one minor last thing.
Hold on. Yeah, sounds like that Jennifer doesn't believe you guys.
Well, it's not minor. In their reply to the state's trustee's objection, the debtors claimed that they never received notice of the initial debtor interview, and I'm going to take issue with that, and I'm going to...
They're even lying about receiving paperwork. This is like classic pro se mistakes.
Say to Your Honor that we have a paralegal who mailed the notice of the initial debtor interview to the address listed on the docket sheet. That paralegal would be prepared to come in and testify under oath that he mailed out that notice. I find it extremely odd that Mr. and Mrs. Owens claim they did not receive that notice, but yet they were able to receive my objection to their stay extension, which was also sent by first class mail. There was no email address on the record, so as Your Honor knows, we were required to serve these pro se debtors by first class mail. That was the only method that we were allowed to send them service of the notice of the IDI, the initial debtor interview. And they completely ignored it. They didn't show up. That messes up the schedules of people in my office. And I think that by allowing this case to continue and giving these debtors an opportunity, even a short one, to try to file new schedules that might have, again, more misrepresentations, all we're doing is postponing the inevitable and allowing these debtors to continue abusing the system. And that's what this is.
Yep. That's what it is. It's exactly that. Exactly that.
Thank you, Your Honor.
All right, thank you, Ms. Ramo, and I appreciate the position of the U.S. trustee, and I certainly have no issue with the mailing of the IDI to the debtors, and I don't understand why they assert they haven't received it, since under the mailbox rule, the presumption is that they did in fact receive that. I do not have sufficient information. I do know the debtor's motion for extension of time to file or amend the schedules did indicate that they understood that they were skeletal. I mean, I do think that there are certain discrepancies that need to be explained.
Are all three of them in trouble? What do you mean? All of them are in perilous financial trouble because of the decisions they make, but only Laura is being rung up for the felonies for the perjury. Problem is they are paying for an attorney, and yet they will claim later in a hearing a month from now, or a month from this hearing that happened a few days ago, that they have no idea how she's paying for a criminal attorney, even though they say they support her 100%, and that's where their money goes, is supporting her. They don't know when to shut up. Exactly. They do not know when to shut up.
If they can be. But on this record today, I'm not prepared to lift the stay, given that this is the debtor's primary residence and time is short, and they filed under, it sounds like, some dire circumstances. So I will exercise my discretion to impose a stay under Section 105 for the temporary period for the court to determine whether a further stay is appropriate under the circumstances. I hope I have articulated to Ms. Naylor and Mr. Owens the court's concerns, and that on this record it does not appear that there has been a sufficient change of circumstances. But I will wait to see what the schedules and statements indicate, and I would ask again that the parties follow the rules when they file the papers. I know Ms. Naylor's papers complained that the creditor's objection, which has been withdrawn, was not timely filed because it was several hours late. And if she's going to make the complaint that others should follow the rules, I would remind her that she needs to follow the rules as well. So with that, let me turn to Ms. Hall and get a continued hearing date. And I'm looking for something shortly after June 26th and probably after June 30th, which is the 3/41 date.
Yes, Judge, we can set that for
I think the rest
Wednesday,
of this is bullshit.
July 1st at 2 p.m.
All right, Wednesday, July 1st at 2 p.m. Ms. Jaimo, will you be traveling? Do you need to appear by video? You're on mute, ma'am.
That's the rest. We don't need. I don't think that anything happens after this. Let's see.
Or to ask about GoFundMe.
Oh, yeah. So then, okay, yeah. Actually, this is a. So then, somebody that's in the chat, obviously viewers that are following this closely, messaged the court and says, "What about the GoFundMe? The $140,000 GoFundMe?" Time crunch, where those papers are due on Friday and the 341 is on Tuesday. So I appreciate your office's need to have a quick turnaround. So Ms. Naylor and Mr. Owens, I'm going to direct that you email those documents to Ms. Jaimo's office, as well as filing them with the court's records, so that she will have them as soon as possible.
And which documents specifically are you talking about?
The documents that Ms. Jaimo has requested and the amended papers you're planning on filing.
The amended schedules, then?
Correct.
Okay. Okay.
Yeah, the ones that aren't bullshit.
All right. Your Honor, may I say one more thing?
Just a moment. I have a question from the court. What is that?
Yes, we got a message from Helen in the chat asking about, I'm guessing the court to ask about GoFundMe.
Ma'am, you are appearing by Zoom, as is Ms. Jaimo and others, and apparently there was a query to the court deputy through the chat system requesting the court to ask you about information where you have set up a GoFundMe site.
Yeah, that'll be tomorrow, Fletcher.
Did you wish to address that?
Your Honor, I imagine this has to do with the smear campaign, which has been going on against our family for
All right, hold on. Okay, finish, Jan.
the last 3 years.
Jan, I would like to know exactly what you're calling this smear campaign. Is it a bunch of people online saying that your daughter's a liar, a proven liar, and she refuses to tell the truth, and she'd rather go to prison than admit the truth, and that you guys are feeding her delusion, and that you guys also feed into not being honest about her lying to these other guys and trapping them in basically litigation hell, and You have this GoFundMe that suddenly all the money's gone, and you say you're bankrupt, but you don't know where it went, and it definitely wasn't for your lawyer, for your daughter's criminal trial, which it definitely was. Is that the smear campaign you're talking about? Because that's not a smear campaign. That's called publicity and spreading information. Because what's going to come out? Is it going to come out that, oh, no, you definitely didn't do anything wrong? Oh, your daughter didn't lie. That would be a smear campaign. But if it's just repeating the information, that's not a smear campaign. But go ahead, Jan. Just like Laura, where she's like, oh, it's the Justice for Clayton. It's the mob. They're all up. They're tormenting me.
A GoFundMe was set up on behalf of my husband by friends.
Wow.
And that was set up in December.
Oh, it was set up by friends? Because later you're going to testify that it wasn't set up by friends. Mm-hmm.
Of 2024.
And their stupid GoFundMe, I looked at it, they set a goal of, $60,000. Then once they hit that, then they're like, okay, 120. And then once they're like, okay, 140. It's just a scam.
And it was set up at that time in an effort to try to help us prevent the bankruptcy situation.
Yeah, you got $140,000, and yet you still have to declare bankruptcy in addition to the $21,000 a month? What are you talking about, ma'am?
Your Honor, may I, if I can just intervene here real quick? I think what the issue is that there was a GoFundMe set up in the name of Mr. and Mrs. Owens, and I think there was over 100,000.
So, I mean, it seems like Jennifer Giamo knows exactly what this is. So it's not the people messaging in, and then that's what's causing people to know about the GoFundMe. Jennifer Giamo already knew about it. She was 100% going to bring it up.
$1,000 generated, and that was never disclosed in the Chapter 13 or in this case. That's what the issue is. And that was something that I was going to delve into in the 341 meeting.
Exactly. There you go.
All right, thank you. Let's go ahead and wrap up this meeting, this hearing. Did you give me the hearing dates and times?
Yes, I did, Judge.
We apologize.
Yeah, that's July 1st at 2 p.m.
So July 1st at 2 p.m., we'll resume this hearing. The court will impose a temporary stay or extend the Section 362 to stay via Section 105 temporarily until the conclusion of that hearing, when the court can consider in a more fulsome manner the schedules and statements that are forthcoming, the amended schedules and statements, and any other papers. And again, I've directed Ms. Naylor and Mr. Owens to email to Ms. Giamo any papers that they file with the court, and also the papers for the IDI. And with that, I believe everything is concluded at this time. Is there anything further? Ms. Giamo, I see your hand.
Yes, Your Honor. I just want to clarify, are you allowing the debtors to refile more pleadings in support of their motion after filing the amended schedule?
Well, there's people, it's not a bunch of people. I want to make that very clear. Like, when you look at it, there's people donating like $5,000. It's basically their friends and family. Because she said on there, oh, we have health problems and we're financially ruined and we don't want to lose our house. But then they use it to pay their AC credit card.
Your extra pair of panties.
Oops, sorry. Lauren, shut up. Shut up, Lauren.
And if so, I would ask that I would be given an opportunity to reply.
I actually have not asked for that. But
I prefer that, Your Honor. I think that the schedules should speak for themselves.
I agree. We have a motion, we have a response, and we have a reply, and that's all the court needs. Okay?
Very good.
All right. Any other questions or concerns, Ms. Naylor or Mr. Owens?
Yes, I have. So the 341 was scheduled for the 30th. Where does that stand?
It's still scheduled on that date and time.
On the 30th. Okay. And the continuance is July 1st. Okay. And the other thing is, I wanted to sincerely apologize with regard to the IDI. We did not get any notification in the mail about that. And I have gone back because I get daily notifications from the U.S. Postal Service with photographs of every piece of mail that I'm getting that day. And I have gone back and looked at the mail that was delivered, and what was in there for every day since we filed on May 22nd. And there was nothing that came to us with regard to an IDI or anything like that. So I have looked because I thought, did I miss it, or and it was not on the docket. And in fact, I had called.
It doesn't belong on the docket, and the court would have nothing about it. Let me just ask Ms. Jamo to email whatever it is she's requesting directly to you, Ms. Naylor and Mr. Owens, and we'll move on. This hearing is concluded. Thank you.
Thank you everyone for being here. Please remember to hit the like button if you haven't already. It does help the channel out. YouTube says you will like this video next, so go ahead and check it out. All right, bye. Kiss your fingers.